Hello and welcome. I'm Amritanshu and you're watching Law of the Land on Rajya Sabha TV. Today we bring to you the Taxation Law Amendment Bill 2016. To discuss the issue, I have with me Mr. Rohit Jain, partner at Vaish Associates, and Mr. S. Seetharaman, principal partner, Lakshmikumaran and Sridharan. Now for the highlights. The bill widens the definition of demerger in companies. The garment industry to benefit, as the promoters now will be able to claim tax benefits for additional employees. And the bill increases the current tariff rate of custom duty on marble, granite and travertine to 40%. The Taxation Law Amendment Bill 2016 amends the Income Tax Law and Customs Tariff Law. The bill widens the scope of definition of demerger in companies to include splitting up or the reconstruction of erstwhile PSUs under the definition of demerger.
The Companies Law allows companies to split into multiple companies. This provision enables demerger and allows the income, expenses and profits of the parent company to be transferred to the resultant restructured companies. The Income Tax Act 1961 takes into account these transfers from the parent company for taxation purposes of resultant companies. The bill clarifies that these provisions will apply in case of public sector company is restructured and the resultant company is no longer a public sector company. There was a need to bring in splitting up or the reconstruction of erstwhile PSUs under the definition of demerger. This would give effect to the conditions attached to the transfer of shares by the government.
This bill is going to give a new dimension to the taxation laws, and I'm sure you're aware that even the Customs Tariff Act of 1975 is slated for a change. The best part about this bill would be, which will become an act very soon probably, is also that it's going to take care of all the transformations and all the new initiatives taken by the government, like the Make in India, the Digital India Drive, and even the Startup Stand Up India.
The Taxation Law Amendment Bill 2016 amends the Income Tax Act 1961. The bill takes into account these transfers from the parent company for taxation of resultant companies. Now the new bill clarifies that these provisions will apply in case of public sector company demergers. As per the bill, the resultant company will no longer be a public sector company.
The main problem was that the public sector companies generally tended over the period of time to be a little bloated in terms of the assets that they held, and the utility of that assets for the running business was quite limited in some cases. So what happens is, when you privatize, the new entrepreneur that takes over the management of the company, he wants to only take the assets for which will be useful for it to run as an efficient business. And for that purpose, for example, in the VSNL's case, the land was not required to run that company efficiently. But at the same time, the land could have been used by the government for any other purpose, which is why it's important to take back those non-essential assets, I would say, to the government without any additional tax.
The changes in the Income Tax Act will enable the centre to make use of land belonging to the PSUs and use the land for public benefits, including housing or as it deems fit. The Taxation Law Amendment Bill 2016 was introduced in the Lok Sabha on 10th of August 2016 by the Finance Minister Arun Jaitley.
The amendment in the definition of demerger will enable the government to transfer assets which were earlier not used by the PSUs without paying the capital gains tax. The new definition of demerger will enable the government to utilize the resources which were earlier not used. With cameraman Sanjay Kumar, Dipali Pandit for Rajya Sabha Television.
A small tweak, but the implications are huge. And that's what we would like to understand from you, sir. This entire thing of bringing into ambit the demerger of a PSU within the definition of demerger, implications of it straight away. 1, 2, 3.
Okay. The current amendment is to bring in a new explanation called explanation number 5. There is already an explanation number 4 which says if there is a split up or reconstruction of public sector companies into several companies as a result of or as a condition of as the conditions notified by the government, then that is deemed to be a demerger. They have said this. The current thing is talking about public sector companies only. But the amendment is, if the public sector company has ceased to become a public sector, ceased to be a public sector company, and thereafter it has to do certain activities, do certain demerger, etc., in order to give effect to the conditions attached at the time of sale of the public sector undertaking, then they can do so. Then also it becomes a demerger. Now, if this is not there, you will not be able to enjoy the tax benefits for demerger of assets that are held by an erstwhile PSU, but still the government has certain shareholding in it, and those things are, even though they are part of the conditions for transfer of shares by the government, that could not be effected. So that is the reason why they have introduced this cost.
So basically it brings in or injects into the system more dynamism.
Yes.
That's the basic. So people will be able to now also take tax benefit. The government will also be able to take advantage of assets and so on and so forth, and reconstruct the entire entity into a new entity.
Correct.
So it facilitates that and makes it more dynamic.
Correct.
Anything that you would like to add, sir?
Yeah, I just want to add this. You see, under the provisions of the Income Tax Act, if any company which is owning an asset transfer a particular asset to another company, even though the shareholding may be the same, that results in taxation of capital gains, 1, in the hands of the company which is transferring the assets, 2, in the hands of the shareholders of that company. What this provision basically says, and therefore, in order to make all those demergers tax compliant, a specific provision was inserted in the form of section 219A. And if subject to fulfillment of those conditions which are prescribed, then it is treated as a tax compliant demerger, which results in tax benefits both in the hands of the shareholders as well as in the hands of the company. Now, what the existing provision required was, as a condition precedent, was that the shares have to be issued to the shareholders of the existing company, and this resulting company, in the resulting company, the shareholders of the existing company should continue to own the shareholding. Now, if, for example, in a case of a PSU, if ever it were to be split and it required the change in the shareholdings of the central government, then it was not tax compliant demerger in a strict sense.
Correct.
So therefore an amendment was required in law, and therefore initially they brought in explanation 4, which was referred to. Now explanation 4 actually was for splitting up or reconstruction of various PSUs, corporations and various organizations, and under which there was certain, the notification was also issued, which also specifically covered a situation where a PSU assets are transferred to another PSU, and there is a change in shareholding of the PSU which is transferring the assets. Now explanation 5 is only basically a clarificatory amendment covering the situation envisaged in explanation 4, to cover a situation where an entrepreneur takes over a PSU, but he does not require an asset which is to run the existing business. He can split the business, transfer those assets in another company, and that another company may or may not be the PSU, which would obviously depend upon the conditions which are notified.
This is the technical part of it. How is it going to bring benefit in terms of revenue to the entities who are involved?
Okay, long-term benefits to the entity would be the assets of the existing company which has ceased to be a public sector undertaking because the government has divested its shares, say to 51%.
Right.
So now it is not a public sector, but it has a large number of assets.
Yes.
Those assets could not be put into any productive use because the conditions at the time of divestment would have been so strict that the government might have put in a condition saying that these assets are not forming part of this divestment process. So you cannot use it, you cannot divest those assets.
Right.
Supposingly, if there is a huge land bank with a public sector undertaking,
Correct.
and when the government is divesting its shares, it could have put in a condition saying that the land bank available with this company shall not be divested off by the new entity or after the divestment,
Right.
which ceased to be a public sector undertaking. Now, there is a land bank
Yes.
with the public sector undertaking, with the so-called public sector. Now it has become an erstwhile public sector undertaking.
Yeah.
You have to actually keep that asset, whether or not you like it. You cannot divest it. You cannot put any other use. So therefore, the assets are non-productive.
Correct.
Under this, those assets can be divested into a new company, and that new company, reconstructed, that new company may make use of it.
Yeah.
And that new company may be a public sector, maybe a private sector, maybe a mix, whatever it is.
So it allows several permutations and combinations
to be done.
Happen.
Yes.
On the capital gains tax, what is the benefit or what was the disadvantage as of now, as of today? If the same scenario happens, what is the disadvantage?
No, just to take this example forward in the context of capital gain. You see, if I was an entrepreneur, I wanted to invest in an PSU. I may not be interested in the land bank which is available with that PSU.
Right.
So therefore, if I were to invest in that PSU and thereafter transfer the land bank to another company which may or may not be a PSU, that would result in a capital gains tax in the hands of the transferor company.
Yes.
Which would result in 20% of the tax on the consideration which is on the amount at which those land bank is transferred to another company.
So what you're saying is, as of today, the provision doesn't allow you to transfer or reconstruct a company only on land base on which the government could have put certain clauses or certain hindrances, right? And because of that, if you were to do that, if you were to make use of that, on top of that you had to pay
tax, and that actually
20%
changes the value of the business or the enterprise which I am taking over.
Yes.
So if I were to invest 100 rupees in a business, I would, if the benefit is not available, I'll have to take into consideration the fact that the capital gains tax, which I have to pay if I were to transfer the asset subsequently.
Right.
That will reduce the enterprise value by that amount of the tax value.
Time for us to head into a break. When we return, we will talk about the amendments in the Income Tax Act 1961 and Customs Tariff Act 1975. Welcome back. The Taxation Law Amendment Bill seeks to rationalize and grant benefits to the garment sector. Once the bill is approved, they will be able to obtain tax benefits for even employees who have worked for 150 days. The bill also increases the current tariff rate of custom duty and rough marble, travertine and granite to give a boost to the Make in India initiative.
The Income Tax Act 1961 allows businesses to obtain a deduction on taxable income to the extent of 30% of the cost of recruiting a new employee. The law requires that the employee should have been employed for a minimum of 240 days in the previous year. The bill relaxes this limit to 150 days for businesses which manufacture apparel. As the business of manufacturing of apparel is linked to varying demand in various seasons, there was a need to reduce the period of employment of employees employed in the garment sector.
Garment industry as such, it's not going to be a major boom because of this type of an amendment, but it's an additional extra benefit, maybe a small benefit, because every industrialist is looking for some or the other benefits from the government. So even if it's a small benefit, it's welcomed. The only glitch which I see is if the worker has worked with us for 150 days, but the type of worker who's attached with us, who is the doer category, who actually does the work himself, these type of people shuffle a lot. I mean, they just keep rotating, they get better prices with some other factory, they just switch over. So to retain these type of people continuously for 150 days is not an easy task.
The Taxation Law Amendment Bill 2016 amends Section 80 JJA of Income Tax Act. The garment sector stands to benefit from this amendment. Promoters will be able to claim tax benefits for employees who have worked for 150 days in a year.
Government has gone one step ahead for the textile industry. In the textile industry, wherever the export is taking place, there if an employee is working for 150 days, that also has been exempted. So, in order to generate the employment, in order to have the more export in the textile sector, this amendment has been carried out.
Earlier, they could take benefits for employees who were employed for 240 days, and several employees who were seasonally employed did not yield any tax benefit for them. The reduction of minimum working days for a new employee is likely to generate employment. The bill also amends the Customs Tariff Act 1975 to increase custom tax levied on marble, travertine blocks or slabs, and granite blocks or slab to 40% from the existing 10%. Currently, the custom duty on marble, travertine blocks or slabs and granite blocks or slabs is at the rate of 10%. This leads to higher import of these products. The enactment of the bill will enable the government to fix appropriate rate of customs duty on these products.
By increasing the custom duty on the import of marble, travertine and granite from 10% to 40%, there will be a drop in the import of these goods. By this step, the government is trying to encourage the homegrown companies, which will give a boost to the Make in India initiative. With cameraman Sanjay Kumar, Dipali Pandit for Rajya Sabha Television.
How big a relief is it to the garment sector? The number of days that they have reduced from 240 to 150. Now, the garment industry has been demanding this for a long time, sir. What is the net implication for that sector if the number of days an employee has worked for yielding tax benefit has been reduced from 240 days to 150 days?
Yeah. Actually, the garment sector may not have 24/7 for employment for all the 12 months. It's a seasonal employment in many cases. So even if you employ additional people, and if you do not employ them for more than 8 months in the year, the 30% benefit which the Income Tax Act grants would not be applicable to them.
Correct.
Actually, this amendment, to understand this amendment, you should go back a little bit behind. There was a provision which provided for a 30% additional weighted deduction on any new employee you employ during a financial year. I provided those employees are regular employees. If they are contract employees, the benefit was not available.
Correct.
Then in 1st April 2016, they amended it. This contract employee conditions are no longer there. Additional employee and all the benefits including PF etc. are paid by the company.
Right.
Then you can get the 30% benefit.
Correct.
They put in a condition, if you are going to do this, you should have at least employed them for 240 days. Now this 240 days cannot be applied on all the industries. Now government sector has come to the government, represented it perhaps, and then government has given a relaxation that it will be 150. But what I am feeling is probably there will be more such industries who would come up and ask for it, and the exemption would expand slowly.
And cover a lot of
other
sectors.
seasonal industries and sectors. There may be demands from various sectors of the industry. Probably government has to take a call. But today it is a benefit extended to
the government sector. But it is likely to, because this is a test case. And if it enhances employment, and if allows companies to take advantage of it, why not? They will broad base it, but it has to work to the benefit of the government and to the people.
And it is in a way good, because this is one direct benefit which a company gets for employing more people.
Yeah. So
we have to give such benefits.
Yes. Now, we'll go back to the original demerger discussion that we were having. Sir here had pointed out just a while ago that the entire thing may not be able to help the already divested companies who have no such conditions attached during transfer of shares. So, what you think will be the case if it will not, and why shouldn't it apply there?
You see, as sir rightly pointed out, one of the condition precedent for a tax compliant demerger as defined in section 219A is that the condition for transfer or the splitting up or reconstruction should be pursuant to an existing condition in this share purchase agreement or a transfer agreement. So if that condition is not there or there is no specific clause for transfer or the splitting up of the business, then in that situation it may not be treated as a tax compliant demerger, which would obviously has a consequential effect on payment of capital gains tax, no benefits to the shareholders, etc., etc. But insofar as the existing company with the demergers or the splitting up which have already taken place, whenever a new entrepreneur comes in and buys a business, he does a valuation of the business. When he takes into consideration the valuation of the business, he takes into consideration the various assets which are there, what are the future tax liabilities which are going to arise if he were to divest a particular non-core asset into another company, which may ultimately be transferred to a PSU or to a private entrepreneur. So he does take into consideration that aspect while investing into the PSU. So therefore, probably taking into consideration that fact, insofar as the existing companies are concerned, wherever unless there is a clause in the agreement itself, they don't want to give that benefit to the existing PSUs.
I'll come to you, sir. As you pointed out, the center word finds its place in the entire bill. But even the state government's own PSU, will it apply to them as of now according to the bill or not?
Yes, the explanation 5 that is proposed to be introduced, it says split up or reconstruction of a public sector undertaking in which the shares have been transferred by the central government.
Yeah.
So if there is a similar situation faced by a erstwhile PSU of a state government, this amendment will not help. Probably this might need a separate additional explanation, maybe explanation 6 to cover such cases.
Right.
But we do not know whether there are such cases as of now, but probably this explanation has been introduced only to take care of the central PSUs
entities
that are facing problems.
And also the point that you were making on transfer of shares and the condition should be imposed only during transfer of shares.
Yes.
What was that, sir, if you can?
See, my issue is the demerger provisions will apply if the splitting up or reorganization of the organization has been done as a condition imposed or attached to the transfer of shares by the central government. Now, there may be situations where no such conditions were imposed at the time of transfer of share, but a subsequent condition was alone imposed. In such cases, whether this explanation would help or not is a big question mark.
Your take on that?
Technically, sir is right. Actually, in that situation, if there is no such condition in the SPA, the share purchase agreement, etc., tax, it may not be, it may not qualify to be a tax compliant demerger. So therefore, it may not cover that kind of a situation.
So effectively, what sir is trying to say, and what you are also agreeing to, is that if there is no conditionality during transfer of shares, then this new definition or amendment will not apply.
Correct.
Huh?
Correct.
And what needs to be done to ensure that it applies to them? That's my question.
No, that actually would require the change in the language of the section itself, because the section itself specifically provides if the transfer or the splitting up is taken place pursuant to a condition in the share purchase agreement or the condition for transfer. So this would require a change in the language itself.
Language. What about you, sir? How do you think it can be included?
Now, if there is a real practical situation in which PSU has actually been divested without any conditions attached to the transfer of shares, then probably a new explanation would have to be brought in.
Moving on, my colleague Dipali Pandit spoke to Shahid Khan, former member, Central Board of Direct Taxes, and tried to get his point of view.
What difference would the new definition of demerger have?
Basically, what they are trying to do is that they are trying to give greater flexibility to the owners or the shareholders of a company which has been taken out of public sector and put into a private sector. So the management can, hive off different units or amalgamate them with some other companies. So all benefits which would be available to a private company, private sector company, would be available to those companies also. That's the whole idea.
How will this bill benefit the investors and entrepreneurs?
Tax neutrality is both with reference to the company as well as with reference to the shareholders. So, I mean, if, for example, if two companies are merged, then the shareholders of one company transfer their shares in that company, so that to accomplish merger, the transfer is outside the purview of capital gains, to make it tax neutral for the investors. So once this transaction comes within the definition of demerger, then all those benefits will be available to investors, and not investors, shareholders particularly.
Thank you, sir, for joining us in this discussion. It's time for us to end the show. You can email your suggestions and comments to law.rstv@gmail.com. You can also watch our shows on the RSTV page of YouTube. We'll be back with a new issue and a new episode. Keep watching Rajya Sabha TV.